So I guess it could be quite a controversial topic or a sensitive topic about, when to actually have your own trust if you're getting married and when to put separate trusts.
It definitely can be a controversial topic, and it really depends on where each party is in their estate planning, in their asset acquisition, and also how they're approaching marriage. Some people will not even consider a prenuptial agreement. Other people will consider a prenuptial agreement. Oftentimes there are inheritances that may have already been received or are projected in the future, and those don't automatically get funded into a marriage. They're not automatically considered marital property or marital inheritance. Generally, those are going to be considered individual properties. So if you own a home and you are getting remarried after you've had children and you want to protect that particular asset to be inherited by your children and not bring it into the marriage, essentially, what you can do is create an individual trust to safeguard any assets that you would like your beneficiaries to acquire without having to have them compete with your new marriage, essentially. So they can create that individual trust, fund the assets and the property to that trust, and then identify the beneficiaries from there. And then anything that they would like to take into the marriage or acquire after the marriage can go into a couples or a joint trust for that marriage. And of course, if the other spouse has other assets that they want to safeguard and not bring into the marriage automatically, they also would benefit from an individual trust. So each party creates their own trust, funds those assets there, and then they come together for a couples trust or a joint trust for anything that they want to be considered marital property.
And is there any kind of black and whites as to when a couple should just not have a joint trust?
Nothing that's like pointing out to me. It really depends on how they treat their marriage. Everybody has the way in which people approach marriage is very private and personal, and it really depends on their circumstances. So I have a couple that I'm working with that each party will create an individual trust. Part of that reason, though, is that they're both very successful. One's a very successful business owner and the other's a doctor. And so they have licenses that they have to protect. They have businesses that they have to protect. And it makes more sense to have those assets funded to their individual trusts and under the doctor's licensing and whatnot there. But even though they each have their individual trusts under these circumstances, they're also coming together to make a joint trust because they're acquiring a property together. And there are other properties that each of them want to bring into the marriage. So I would never say that a couple shouldn't necessarily have a joint trust. What I would say is standard couples will typically have a joint trust. Under certain circumstances, it will make sense for each of them to also have an individual trust as well.
And is it a sign of a difficult relationship? Or is it a sign of a lack of communication if people are not actually having these conversations? Or is it just, everyone's individuals, everyone's they are where they are?
For the average couple, a prenuptial agreement may or may not come up. It really, again, it depends on their assets, their backgrounds, their potential inheritance. But if a prenuptial agreement is being discussed, then individual versus couples versus maybe all three will typically come up. If a couple is in a space where they are discussing a prenuptial agreement or how to bring assets into a marriage or how to keep certain assets out, depending on circumstances, typically an estate plan will come up into those conversations. But the typical couple these days, well, that's hard to say, right? Because it's like 2023. So people are getting married later in life. They're acquiring more assets. So I think now more than ever, it makes sense for these parties to be educated and to be having these conversations when it's when they're in a space where they are planning for their marriage, versus when my parents got married or my grandparents got married, because they got married so young, they didn't have things to protect at the time. They acquired things over time, which is when it then made sense for them to come together for a joint trust. They had already brought everything that they had into the marriage because it was virtually nothing. They were like 18, 19, 20 years old, right? So as our economy changes, as the way our citizens shift in habits, being married at 18, 19, 20, 21 years old back in the 50s, 60s, 70s, maybe even 80s made sense. And it was like kind of an expectation. Whereas now the average male's getting married after 30, the average woman's getting married, I think after 27, something around those lines. Most of them are typically going to have already acquired assets prior to the marriage. So this shift in habit surrounding marriage in the Western communities in America makes it more important than ever for these families to be having these conversations. Whether they're educated on them or not is kind of a different story.
And if they're having two separate trusts and then a joint trust, is each trust private, or can both parties, as normal, are they totally open to what's in there? Is it kind of a open conversation?
Your trust is as private as you want it to be, right? So, I mean, it is important that the people that you love have access to the documents, because if you can't find the trust, it might as well not exist. Right. I've had clients I had a gentleman call me last week where his grandparents had funded their home to the trust, but nobody could find the trust. They didn't even actually realize it existed until they went to go clear a title. So as far as California is concerned, the trust doesn't exist, but they can't clear it from the trust until they go to probate to get permission to have the legal authority to do it. So it's important that your trusted people, whether that be an attorney or a CPA or your partner or somebody, that you would trust enough to give power of attorney to, they should have a copy of the document. So generally speaking, when you have an individual trust, you can still make your partner beneficiary of that. Typically, if it's an individual trust, your partner's not going to be a co-trustee on there. You could make them successor trustee. You could also make them a co-trustee, but generally what happens is the party that's creating the trust is the sole trustee, and then they have successor trustee, second successor trustee lined up. So say, again, let's circle back to you're getting remarried, you already have kids. You may want your spouse to get 25 or 50% of whatever wasn't brought into the marriage. And so in that case, you would make your partner either 25 or 50% beneficiary, and then whoever else you would want to also benefit from that individual trust would be designated the other percentages. So perhaps they do want 50% to go to the spouse, but they want to protect their kids' right in inheriting the other 50%. That's how the document would specifically call for that distribution, versus it being funded to a joint trust. In a joint trust, that's equal ownership, equal partnership. Like if you have a joint trust and one party, the co-trustee, dies, the other co-trustee has complete control and rights to the full estate until that person passes away. So it doesn't necessarily protect the kids from the previous marriage from inheriting when funded to the couple's trust, because the surviving spouse still controls the assets and the trust until they pass away. And that's when the distribution happens. So for example, say dad dies, wife still controls everything. She can change the beneficiaries. She can sell everything off. It's to her benefit unless it becomes an irrevocable trust at the time of the passing. In that case, nothing can be changed, or a certain portion may get split out into another trust that's irrevocable and would have to be distributed the way in which the document calls for, which that form of requirement within the legal document is normal when there's remarriages and children from previous marriages. So for example, if you put an irrevocable clause into the couple's trust at the time of the first party's passing, they can say that 33% of this estate needs to get funded to a separate trust specifically for my 3 children or whatever. And then that portion of the trust like separates out, and they're required to create a separate trust specifically for those particular assets to be set aside and distributed as the document calls for. So there's different ways to protect yourself, but the most logical and conducive way is to just not commingle those assets and keep them in individual trusts separate from the couple's trust.
Okay, so the one advisor can handle both parties and the joint together. There's no conflict of interest.
No. There wouldn't be, unless, if one partner's like, I don't want an individual trust and everything should come to, that's something that they would need to iron out. But if they come to us and they say, I have this house from a previous marriage, I want this to go to my kids, or I have this business and I need it funded to its own separate trust, and they already know that these are things that they want, or they're asking me for educational material that's already been signed off on by an attorney on how to handle these type of situations, it's very clear once you understand, okay, this person needs to protect this property, this person needs to protect this business, and then together through the marriage, we want to acquire a home, we've got retirement accounts, we have XYZ. So in that moment, there isn't a conflict of interest because each person knows what they need to do, and each person knows that individually they need to protect a few things before they join forces, essentially, and commingle different assets into the marriage.
If you're doing your estate plan, the documents are there. Are they physical documents, or do they have to be physical documents nowadays, or can they be digital copies?
So that's going to depend on what state you're a resident of. Right now, California is still not digital notarizations, right? Yep. There are other states, Montana specifically, they're great. They do online notarization, which means that we can do everything digitally. And then also, regardless if we do the execution of your documents via a physical notary or online, we will either way receive a scan back. If the notary comes out physically to do these documents for you, they'll scan them back to us so that we can preserve a copy of the document under our forever storage option.
And so being blunt, you don't need to have a paper copy anymore. It's not just has to be a physical paper copy.
Again, it's going to depend on the state that you're in. And some, like the court is going to want the original, like in California, if we have to go to probate, they want the original hand-signed documents. So focusing on the state of California, as of right now, yeah, you do need to have a physical version. But if you're going to the hospital and you're saying, like, here's the medical directive, and you pull it up via email or through our portal, that will suffice. That'll do what it needs to do. If you're transitioning your bank accounts, or you're opening something, or you're purchasing something through the trust, depending on the company that you're working with, depending on the bank, they may want to see the actual physical documentation. They may be okay with the digital copy. It really depends on who you're dealing with.
But tucked away, having it digitally obviously makes total sense, but it probably makes sense to have a paper copy kicking around as well, even in these days.
Right. If there's a digital notarization, if you can get the documents digitally notarized, in that case, more than likely that state's going to accept the digital copy. But if the state is still on the physical copy portion and that the documents have to be notarized in person physically, the state's probably going to want a physical copy of that. So it really depends on the state you're in. I would say 80% of the states in the US are going to accept that digital, and then you're going to have your more strict states, specifically California, that will likely say, let me see that physical copy.
So on the physical copy option, where do you store it? Who stores it? Do you store it in the bag? Do you store it under the bed, or do you store it in your drawers? Where do you store the physical copy so that people have got access to it?
Yeah, so personally, I would put it in a fireproof safe with my other vital documents, right? So I've got a little folder for each kid's birth certificate and the things that we all need from time to time. So when we have to come out and do the physical copy, our notary, our mobile notary does the printing and the 3-hole punching, and they bring it in a Legacy Lighthouse binder for you. So we're already going to have a place for you to store it, and it'll be you'll be able to put it in the safest place that you see fit. And we're also going to send you that digital copy as well. So we'll already have a nice little folder for you to keep everything in. It's part of your package. They'll leave it there with you after they do the scan back. Once you have that done, it's important that your trusted people know where to find it. You can also send them a digital copy as well, because as soon as our notary leaves, they're going to be scanning it back to us, and then it will come back to you via digital access.
And the last question around access is about, if you got the digital option, do you co-share passwords with your spouse or your partner to give them access? And how does your partner or the beneficiaries actually get access to it whenever the time comes? And then how is that triggered so that they've suddenly got access to it?
Essentially, a trust is a document. It's an entity. So, when you go file at the Secretary of State in any state to create your business, and then you physically formed an entity through filing that documentation. Well, this is the same thing, but it's a different type of document. So you're forming an entity to hold your assets, to get them out of your personal name so you can continue to control them, but they don't get stuck there. So step 1 is to have your successor trustee and your second successor trustee know that they are those things, that you've elected them to act as those things. And step 2, get them a copy and let them know where the original is. You can keep it in a safe deposit box at the bank. You can have your fireproof safe. You can put it in a desk,
How do you get access to the digital copy? When someone sets up an account with you, do they have passwords for their spouse or access for their spouse?
Yeah, so we will store that for you digitally through our subscription plan. So with the subscription plan, you get lifetime access to your executed documents. You get lifetime access to editing your documents. We can offer you discounted options for special needs trust if you find that you need special needs trust for incapacitated adults or minor children. If you need to fund other deeds to your trust as you continue to acquire assets, all of those services are included in the subscription fee.
I come to you, set up a trust. It's in my beneficiary is my spouse. Does she get access to it? So when she got a password that gets her access to the documents so that whenever she needs them, or is it set up jointly so that both of us get access to them even when I'm still alive?
If you have a joint trust, then you'll share that account. If each of you has an individual trust plus a joint, then each of you will have your separate accounts and your joint account will be together. That way, if you want your privacy protected, then you don't have to share those things with your partner. If you don't mind sharing those things with your partner, then you can give them access. And then we can also designate a legacy contact. That way, when you do pass, we already have somebody on file that we know we can grant access to your estate plan directly.